All right, what are the first few steps you should take right after inventing? Hi, I'm JD Houvener, owner, founder, and patent attorney here at Bold Patents Law Firm. Also the author of Bold Ideas, The Inventor's Guide to Patents. You can get a copy of that book at the link below. It's the Bold Inventor Kit. I put this together just this year for you, YouTube watchers. So click that link and get a copy of the PDF today. So this question is important. What are the first very few steps you should take after you've invented? I would say the first thing is to work with a patent attorney. Make sure what you've discovered is truly unique, novel, and non-obvious. See if it's patentable before you take any steps to publish, sell, or even prototype your invention. This early step, well, I know it can be perhaps time intensive, it may be scary talking to an attorney about your invention. This is the first step to take. What you can do is work with that attorney very carefully and talk about the scope, breadth, and whether your invention has enough meat on the bone, if you will, to warrant moving forward with a patentability search or maybe even a patent application. The beauty here is the attorney will help guide you in this early phase to see, do you need to collaborate more with some other inventor to bring about this invention, to build it? Do you need to work with a third-party engineering team or designer to flesh it out before you file? And if you do so, you're going to do it the right way, because you're going to get the right introduction from that patent attorney to a business attorney to help you draft a non-disclosure or confidentiality agreement as part of the working together relationship. If you have co-inventors that are both coming together and have that shared vision, your attorney will advise you to talk with a business attorney to form a company and document a founder's agreement between the two of you inventors, so there's no loose ends. So that if you two decide to break up much later, you'll have a foundation, you'll have that operating agreement on how to move forward together and how to break up apart when you've set up the business from the onset. Too often I've seen 2 or 3 person inventor teams break up later and not have anything documented, and it's really a lot of finger pointing. And unfortunately, as patent attorneys representing those individual inventors, we have to disengage. Now each of you have to go find separate counsel, and it can be a real mess. And honestly, stop innovation in its tracks. Now, aside from speaking with your patent attorney, that's step number 1. Step number 2 is to conduct a patent search. Now, I mentioned this briefly, but this step cannot be missed, especially if your invention is outside of what you do on a day-to-day basis. Inventing on a new area, if you're not doing this day in and day out, you're likely going to not understand the complete state of the art. Okay? It's not something that's your fault. It's just the fact that there's no way for you to know exactly where the state of the art is, where a person of ordinary skill, a science major, technology, someone who's developing a product that could be a competitor, is doing, what they may have filed, what the invention they have just filed might be. So what you can do is work with a patent attorney and their search team to look at what has been filed and published, what has been, what is known, what is patented in the world within your invention technology, within your classification area. A professional search will be your best option to know whether to proceed to file a patent application, or perhaps pivot and go back to the drawing board and design around what's called a prior art, or design around another technology that's already been filed or published before you. Having this information about whether you might be able to get a patent or that you're not stepping on someone else's toes is incredibly valuable right up front. So that is step number 2. I'd say the third step is filing that application. If indeed you have found, after conducting a search, that you've got a really wide band, that the scope of the patent protection you could get is big and will be able to help you make a dent in the market, that is a wonderful opportunity for filing a patent application. Step 3 is to file it, and that is the application drafting, whether it be a provisional, non-provisional, or design patent application. Your patent attorney will help guide you on the right option. These options can differ, of course, for really any situation regarding financing, and mostly whether the invention has been developed, what the maturity level is. If it's really in the early stages and still in the concept phase, maybe a little bit of prototyping has been done, likely you're going to want to move forward with a provisional application. This third step is critical to give you that additional time to then go back, build your product, engineer, design it, and get it just right. And then once you've got a product that's ready to sell, That's what you file the non-provisional for. So I'll step back for a minute and let you kind of take a back summary, if you will, of those first 3 steps. First one, speak with a patent attorney. Confide in them about your invention. Help them understand what you've come up with and whether it merits, whether it's eligible for patenting. They'll help put you in the right direction to help get it toward the second step, which is patent searching. Looking at the published documents, patent documents in the past to know the prior art. And step 3 is, if it looks good, it is an application to file, so that the filing date is done as soon as possible. So you get an order, you get those dates, you get that filing date, all important date. For any other inventor that comes after you, you will win the race to the patent office. All right, take those steps if you're onto something big. And if you have any more questions, please do click below our Bold Inventors kit. It's got a lot of great information, including what I just went through, the difference between patents, trademarks, and copyrights, as well as this initial 1, 2, 3 step that we help inventors get through every day. All right, everybody, have a great rest of your day. Go big, go bold.